right. Mr. Jaffe. All right, this is the, are you here on Van Maren versus Davidson?
Yes, Your Honor. Jasmine Davidson is my client, Your Honor.
What's that? So
Yes,
I see Miss Davidson's here. And do I see Edward Van Maren?
Present in the courtroom, Your Honor.
All right, Edward Van Maren is present in the courtroom. So I have a motion for, sir, if you want to come on up, you can have a seat at this table. Oh, actually, you're going to be at that table over there, okay? All right, so I have a motion up for summary disposition. I've reviewed the motion. I've reviewed all of the documents that were submitted to the court. And is there anything that I need to be aware of?
Yes, Your Honor.
Your Honor, excuse me.
One sec. Can I get your appearance, sir? Can you tell me your name?
Edward Van Maren.
Okay, you can have a seat. Mr. Jaffe, give me your name.
Your Honor, good morning. Attorney Brent Jaffe on behalf of Jasmine Davidson. Your Honor, if I could address the court with regards to the motion that I filed, Your Honor.
Okay, so it's his motion for summary disposition. So Mr. Jaffe's going to go first, and then I'm going to hear your response, okay? All right, go ahead, Mr. Jaffe.
Thank you, Your Honor. The motion was filed, properly served on this individual. Sorry, it was his poor decision to not retain a lawyer because he's not a lawyer and he has no idea what he's doing. That being said, he never filed a response, Your Honor. This is well over a month ago. And not only did he not file a response, Your Honor, but I just want to state for the record, and I have verification, but I don't need to get into it. This might be one of the most disrespectful people I've ever encountered in my entire life.
This one's already heating up. You can tell Judge Shackelford isn't in the mood for nonsense today. The lawyer's coming in strong, throwing shade at the pro-SE plaintiff for not knowing what he's doing. And honestly, it's starting to look like this case is less about justice and more about who can keep a straight face the longest.
All right, I don't want any personal attacks. Let's just get to the meat of the case. What is your motion based on? And just get to that. You guys don't have to like each other.
Failure to state a claim, Your Honor. This individual has never presented an iota of evidence to substantiate any claim that he's ever made, but rather this lawsuit was just an attempt for him to defame and harass my client. But again, Your Honor, no response. And respectfully, Your Honor, I would ask that this court hold this person to the same standard that an attorney would be held to. I would ask that my motion be granted accordingly, and this case be dismissed.
Sir, do you have a response?
Yes, Your Honor, I do. First and foremost, I was under the impression that defense never bothered to file an answer to this case to begin with. Moreover, as defense is trying to claim, my attorney was never present during the said case, the previous custody case between defendant and myself. I have been.
So let me ask you this. Let me ask some questions. The parties were you married or dating?
Dating.
All right, so how long, when did you start dating?
We were together 5 years.
When did you start dating?
2018.
When did you split up?
22.
Okay, so you split up in 22. Your allegation is that this,
If I may, Your Honor, we started in 17, not 18. Our daughter was
Okay.
18.
Okay. So basically the allegation is that a bunch of these miniature charges were made. At the time, were you two lit these charges for like $3, $2, $1? I don't know if these are all like phone games.
It's exactly what it was.
Okay, it looks like phone games to me. So these were all charged at the time the two of you were you living together?
Yes, Your Honor.
All right, so you were living together, you were cohabitating.
Yes,
Who
Your Honor.
was working?
I was.
Okay, and Miss Davidson, did you have an infant at that time?
Yes.
Okay, so there's a minor child. So is it a baby at this time or a young kid? I mean, there's no year on IFC like 1106, 1217, 320. It didn't tell me the year these charges were made. Like, I can't tell from looking at the documents that were submitted when they were made. It just says year, or it says month and day.
That is fair, Your Honor, and I do have a stack of papers more than an inch thick of 4 years of bank records. I would be more than happy to bring to the.
Were you guys living together at that
Yes, Your
time?
Honor.
Okay,
But the
so.
record also showed that she emptied my checking account while I was providing for both her and a minor child. One of those instances occurred while I was at a grocery store with a shopping cart full of stuff, and she still emptied my checking account.
All right, but there's no claim for that in here. I mean, I just see the claim is that these are, I don't mean to call them micro
That's
transactions,
exactly what they are.
but they're like $1.05, $1.05, $4.69, 91 cents, $1.05.
Several hundred in total.
These are, well, what is you made a claim for 6,500.
Yes,
What is-
Your Honor, and if I may also point out that during the custody agreement, when we were ordered by the court week on, week off custody on a dozen separate occasions, I have made verbal agreement, which I'll quote Pennzoil v. Texaco, and that verbal agreements are enforceable. I made a verbal agreement with defendant to take child on defendant's court-ordered scheduled week so that she could go out with friends in exchange for her to do the same on my week, and I was robbed of that a dozen times on my weeks. So for the sake of argument.
This is your guys' kid.
Yes.
I'm not a family law court. I mean, none of that is important to me. I have $6,500 of claim damages for a bunch of micro transactions that equal hundreds of dollars. And those transactions all occurred during the course of your cohabitation while you were the primary caregiver.
Yeah, Your Honor, that is correct, Your Honor. That is correct, Your Honor. And again, just to reemphasize that, again, not an iota of information or supporting documents or even be Texaco, whatever the legal scholar is quoting, has ever been presented to me, nor has this person ever contacted me. Again, he was rightfully served, Your Honor.
Well, it doesn't matter. I mean, if they're talking about making agreements outside of their parenting time order and one party's honoring them and the other party isn't, I am a district court judge. I do not do family law. I am not going to overstep my bounds and get involved in that. And certainly, I'm going to tell you my honest thoughts. I did family law for a long time. And if you two can't figure out how to get along on some level, you're going to screw your kid up. I'm just telling you, that's how it is. That's what I see here. And I see it all the time. And it's really disturbing to me because if you two talk poorly about each other, get mad at each other, in front of the child, can't communicate with each other, you are messing a kid up. You are. And I mean, and that's a family law matter. It's not in front of me, but
And Your Honor, I did represent.
I'm very sad to see it over and over and over again. Sir, do you have any other documentation that you want me to look at?
Your Honor, if I could actually go back to the motion in which defense made an effort to claim that my counsel never appeared.
Why do I care?
Because he's trying to have my case thrown out on multiple grounds.
Man, this courtroom feels more like a therapy session than a lawsuit. The judge is diving deep into their relationship timeline. Dates, kids, who paid for what. And you can feel her patience thinning with every answer. She's basically saying, get your personal drama out of my courtroom. This isn't Judge Judy. It's supposed to be small claims.
So he's saying, no. Listen, he is trying to get your case thrown out by saying there's no relief and there's no claim, that there's no legal basis for your claim.
So
Is that you failed to state a claim on which relief can be granted. So I keep asking you, what matters to me is what documentation do you have that she owes you $6,500?
Your Honor, would a couple write a contract for who's going to pick up children from school any given day of the week? No, most couples are not. So in the same sense, if a couple is together and one party owes the other money, are they going to write a contract?
Yeah, the answer is
No, and when one of the so are you charging her for food she ate while she was the primary caregiver for your child and you were at work? Is she have to pay you back for the food she ate?
I'm asking
you a question, and guess what? I got the robe, sir. So I'm asking you a question. Does she owe you money for food, shelter, clothing, that you paid for her while she was the primary caregiver for your child?
Your Honor, she does owe me for food, clothing, and shelter. During the 10-month span that I was under false pretenses, we were going to be a family.
Okay, so no. All right, listen. The request for relief in this case was the maximum that was allowed in district court in small claims. It's since been removed, but the amount claimed was $6,500. And the allegations were credit fraud, defrauding by means of solicitation of prostitution, possession of stolen property, promissory fraud, and emotional distress.
Now this is where it gets brutal. The judge just hits him with pure logic. You want her to pay you back for food, clothes, and shelter? While she was raising your kid. That's courtroom annihilation right there. You can see his whole argument crumble in real time. Even the lawyer can't believe he came to court with this nonsense.
Okay.
I do have several hundred hours of audio recordings held within my own home, as the Exhibit A submitted by the defense shows that the defendant was made aware that everything in my home was being recorded.
Your Honor, may I address the court briefly, Your Honor?
Very brief.
Thank you very much, Your Honor. As a practical matter, I represented my client also in the custody matter for over the period of almost a year. And respectfully, Your Honor, I'm not sure why this plaintiff feels he has a platform to do it. Your Honor. Again, there's no relief has been, nothing's been substantiated, Your Honor. And they actually took this serious, which I don't think he is. And again, I think it's a pure harassment technique. And he would have hired a lawyer, because that's why people pay a lot of money to go to law school.
All right. I mean, listen, Mr. Jaffe, we don't have to get in the mud though. Listen, as far as I'm concerned, I don't see any claim that relief could be granted on. I mean, all of these, when you have two people and look at, I'm going to just use common sense and reason. When you have two people who are cohabitating with a minor child, an infant, or a very young child, what year was the child born in? 2018?
February 2018.
So we're talking about a kid who is not school age,
Correct.
right?
She's 5 now and in kindergarten.
She's 5 now, but all of these purchases, all of these, what I'm calling microtransactions, all occurred while the two of you were in a relationship, while she was the primary caregiver. And there are agreements that are made. I mean, you can look at it with common sense and reason, which is what I'm doing. And we're talking look, she likes phone games a little too much. I'll give you that, but you can't come a year and some after the parties split up and claim $6,500 in an action because of transactions that occurred. She clearly had access to money. Did your client go to the grocery store, Mr. Jaffe?
Of course, for the family, of course.
At the time, no, Your Honor, she did not. She did not.
Your Honor, absolutely. Again, Your Honor,
Yes. I have a court recorder. Do not make her suffer. She cannot type both of you at the same time. Okay, so you're telling me, Mr. Van Maren, that she did not ever have access to any bank account?
She had unlawful access to mine when she saved my credit information in her phone without my permission.
Okay, wait. So the whole time you were together.
My grandfather took me shopping.
So she was never allowed to go to the store or make any purchases?
She went with me.
So she had no access to money. It's your statement. This is what you're telling me. She had no access to any money at all while she was staying home with this minor child.
She couldn't be trusted with money, obviously.
Okay. All right. I find that there is absolutely the plaintiff has failed to state a claim on which relief can be granted. We're talking about microtransactions that occurred during the relationship between the parties where they resided together and had a minor child, and Ms. Davidson was the primary caregiver for said minor child.
Your Honor,
Sir, you have, if you want to file an appeal, sir, you are certainly entitled to that relief. That is my judgment, Mr. Jaffe. Your motion's granted.
And just like that, case dismissed. The judge shuts it down without hesitation. Another day, Another failed attempt to turn heartbreak into a lawsuit. Judge Shackelford doesn't play favorites, she plays by the law. If you enjoyed watching this courtroom chaos unfold, make sure to like, comment, and subscribe.